Welcome to The Explainer. Today, we're going to dig into a huge question in law. How do you build a trust that actually works, that's legally bulletproof? It might sound a little complicated, but stick with me. By the end of this, you'll totally get the 3 essential pillars that hold any valid trust together. Let's jump right in.
So let's say you want to set aside some money, or maybe a piece of property, for someone, a child, a family member, a friend. You want to make sure it's legally protected, managed the right way for them. How do you actually do that? It's something a lot of people want to do, but man, getting it wrong can cause some serious problems.
And the classic legal answer here, of course, is a trust. It's this incredibly powerful tool that splits the management of an asset from the person who gets to enjoy it. But, and this is a big but, for that to be recognized by the law, it has to be built on a really solid foundation. You can't just wish a trust into existence.
I want you to think about it like you're building a house. For that house to be sound and legal, you need 3 key things. Lawyers call these the 3 certainties. First, you need a clear blueprint. That's your intention. Second, you need specific materials, the exact property that's going into the trust. And third, you need to know who the occupants are, the people who are actually going to benefit. If any one of those pillars is shaky, the whole thing just collapses.
Okay, so let's start with that blueprint, the certainty of intention. Now, this isn't just about hoping for something or having a quiet wish. This is about making it crystal clear that you're creating a legally binding duty for someone, the trustee, to hold property for somebody else. It's the huge difference between a polite suggestion and a legal command.
And the words you use, they matter a lot. Take a look at the left. A husband left property to his wife in full confidence she'd do the right thing for their kids. The court looked at that and said, nope, that's just a moral hope, what they call a precatory wish. It's not a legal duty, so no trust. But then on the right, you have Paul v. Constance, where a man told his partner that the money in an account is as much yours as mine. That was enough. The court saw a clear intent to share, and poof, a trust was created, even though he never once used the word trust.
This brings us to a really famous, and honestly a kind of sad case. It's called Jones v. Locke. A father comes home from a business trip, pulls out a check for £900, a huge amount of money back then, and he puts it in his baby's hand and says, "I give this to baby." It was a gesture of pure love. He obviously wanted the baby to have that money.
But the court said this was a failed gift, not a trust. See, he intended to give the check to the baby right then and there, but he didn't follow the right legal steps for that. And here's the crucial legal principle. The law won't step in and save a botched gift by just pretending it was a trust instead. His intention was to give, not to make himself a trustee. That distinction is everything.
Okay, on to our second pillar, the materials, or what lawyers call certainty of subject matter. So you've shown you want to build a house, you've got the blueprint. But what's the house actually made of? You have to be absolutely clear about the specific property that's going to make up this trust. Vague ideas just aren't going to cut it.
Let me ask you a question, because this exact problem came up in a real case called Re London Wine Company. Imagine customers paid for bottles of wine, and that wine was just stored in a giant cellar with a bunch of other identical bottles. The company goes bankrupt. The customers say, hey, that wine was being held on trust for us. But the court asked a very simple question. Which bottles? Until those specific bottles were separated out and identified, there was no specific property to form a trust.
Now, the law makes a really key distinction here. For things that are unique or non-fungible, like those individual bottles of wine, you have to physically separate them. But for items that are fungible, meaning they're all identical and interchangeable, like shares in a company, the rule is a bit different. In another case, Hunter v. Moss, a guy declared a trust over 50 of his 950 identical shares. And that worked, even though he didn't pick out which specific 50 shares. The court's thinking was, hey, they're all the same, so any 50 will do. It's a pretty controversial decision, but that's the law as it stands.
And it's not just about identifying the items. The words you use to describe the property have to be clear too. This is where you run into something called conceptual uncertainty. In a case called Palmer v. Simmons, a woman tried to create a trust over the bulk of my estate. The court had to shut it down. Why? Because what on earth does bulk mean? Is it 51%? 75%? Nobody knows.
Since it's not clear, the trustee can't do their job, and the trust fails before it even gets off the ground. And that brings us to our third and final pillar, the occupants, or what we call certainty of objects. You've got the blueprint, you've got the materials. Now, who is this house actually for? A trust, unless it's for charity, absolutely has to have human beneficiaries who can enforce it.
This quote from Lord Evershed really nails the core of it all. A trust must have somebody in whose favor the court can decree performance. In other words, a trust isn't just some abstract instruction floating out in space. It's a duty that's owed to a person. If there's nobody who can march into court and say, hey, my trustee isn't doing their job, then the whole thing is unenforceable. It's a toothless instruction, and courts don't supervise those. So how certain do you really need to be? Well, as you can see here, it depends on the kind of trust. If it's a fixed trust where the shares are already set, like £10,000 to be split equally between my grandkids, the trustee has to be able to draw up a complete list of every single person. Easy enough. But for a discretionary trust where the trustee gets to choose who benefits from a group, the test is a bit looser. All they need to be able to do is look at any person and say with certainty whether they are or are not part of that group.
But hold on. Even with a perfectly clear definition, a trust can still fail if the group of beneficiaries is just gigantic. Imagine a trust for all the residents of London. We know what a resident of London is, sure, but it's just impossible for a trustee to actually manage or survey a group that big. The courts will look at that and say, sorry, that's administratively unworkable. There's a practical limit.
Okay, so we've spent all this time talking about how to build the house. But what happens when one of those pillars is missing? What happens when the whole thing comes crashing down?
Generally, it goes one of two ways. If the intention to create a trust was clear, but maybe the property or the beneficiaries weren't, the property usually results back to the person who created the trust. It's called a resulting trust. It basically just bounces back to them. But if the very intention to create a trust was uncertain in the first place, remember that in full confidence case, then the person who got the property just gets to keep it. It's treated as an outright gift because there was never a real trust to begin with.
So, let's bring this all home. Building a trust that's going to stand up in court, it's not about reciting some magic words. It's about solid, sound, legal architecture.
Just remember our house analogy. You need that clear blueprint, the certain intention to create a real legal duty. You need your specific materials, the clearly identified property. And you need to know who your occupants are, the beneficiaries that can be clearly identified. Get all three of those right, and you've built yourself a legally bulletproof trust.
And that leaves us with a final thought to chew on. We've seen courts kind of struggle with this stuff, trying to balance what someone clearly wanted against the need for strict, predictable legal rules. So here's the question for you. Where should that line be? Should courts bend over backwards to say a flawed trust to honor someone's wishes? Or, at the end of the day, is the cold, hard certainty of the rules more important for everyone? Thanks for watching The Explainer.